Hello everyone, it is Chris Clark with discgolf.law. Natalie Ryan has filed a new lawsuit in Minnesota. Let's get into it. We did several videos on Natalie Ryan's previous lawsuit that she filed in California. And I expect there will be more to come relative to this new lawsuit that she's filed in Minnesota. So for now, I'm going to touch on some interesting ways in which the Minnesota case differs from the California case we talked about earlier this year. Generally speaking, Natalie is making the same types of claims she made in her California lawsuit and asking for the same types of legal relief. So please go back and check out our prior videos if you want more information and analysis on the California case. Natalie's new lawsuit in Minnesota was filed on June 20th in Minnesota State Court. The defendants are the Professional Disc Golf Association and the Disc Golf Pro Tour. And like in California, there is a third defendant. This time, the third defendant is LaVisca Disc Golf Design. You may recall that's different, obviously, from the California case in that the third defendant in California was Thousand Rated Productions. Here, it is LaVisca Disc Golf Design. In the California lawsuit, Natalie's complaint listed Thousand Rated Productions in the caption as a defendant, but they weren't really mentioned by name anywhere else in the body of the complaint, except in cases where they were lumped into the term, quote, all defendants. In this Minnesota lawsuit, there are specific claims against LaVisca Disc Golf Design for aiding and abetting the discrimination allegedly committed by the Disc Golf Pro Tour and the PDGA. So one difference might be that LaVisca, and again, I'm not talking about any individual when I say LaVisca relative to this case, I'm talking about LaVisca Disc Golf Design. LaVisca may need to play a more active role in the defense of this case than Thousand Rated Productions did in California. As many of you probably know by now, lots and lots of papers get filed anytime there are court filings like this. Generally speaking, there were essentially two things that were filed. Natalie filed a motion for a temporary injunction to allow her to play at the Preserve Championship June 30th through July 2nd in the FPO division. The second thing Natalie filed is a lawsuit. The things Natalie is asking for in her lawsuit, again, align very closely with what she asked for in her California suit. She's asking for a ruling that the defendant's behavior and policies are discriminatory. She's asking to permanently enjoin the defendants from enforcing their policies. And by the way, just this term that I'm using, enjoin, that is the term that is used in these court documents. The word just means legally prohibit. So she's asking the court to enjoin the defendants and their officers, agents, and employees from subjecting Natalie to discriminatory treatment or retaliation. She's asking for compensatory damages, including emotional distress, in an amount greater than $50,000. She's also asking for treble damages, which again, treble is just a legal word that means triple, and punitive damages. Now, to get treble damages or punitive damages, you must have a basis. You can't just ask for it and expect it to be given. Natalie's attorneys cited a basis for both of these requests in the filings. I personally did a quick little check, and I'm not sure that the citation they gave really supports asking for treble damages or punitive damages in this context, but I'm not a Minnesota licensed lawyer, so I may very well be wrong about that. She's asking the defendants to have to pay a civil penalty in dollars to the state of Minnesota, and lastly, asking for reimbursement of her attorney's fees. Speaking of attorney's fees, Natalie has a new team of lawyers working with her in Minnesota, presumably because her California counsel is not licensed in Minnesota. Natalie's new legal team appear to specialize in employee-side employment law claims, and that makes sense. You know, discrimination is a very hotly litigated topic within the employment law arena. I would expect maybe some of the similar issues that this firm deals with in an employment context may also serve them well in representing Natalie. You may also recall that Natalie's California lawyer went on a podcast and mentioned that he was representing Natalie for free. I have no idea what the financial arrangement is between Natalie and her legal team. I would also note that even when a lawyer is representing someone for free, there certainly are costs and expenses associated with litigation that can stack up and really reach a meaningful number. One obvious difference between these two lawsuits is that the California lawsuit was based on California law. The Minnesota lawsuit is based on a Minnesota statute known as the Minnesota Human Rights Act. This act has a few differences as compared to the California law that might matter in this case. For example, the Minnesota Human Rights Act defines sexual orientation as having or being perceived as having a self-image or identity not traditionally associated with one's biological maleness or femaleness. So you may recall the California statute specifically cited gender identity as a protected status in California. Here, what is protected is sexual orientation, but it's defined in such a way to include one's identity not traditionally associated with biological maleness or femaleness. Now, interestingly, the Minnesota Human Rights Act does provide a defense to discrimination or an exception to being liable for discrimination under what they're calling a legitimate business purpose. Unfortunately, what is or isn't a legitimate business purpose is not defined. But I'm anxious to see whether the defendants in this case are going to make something of that. Might they try to argue the policy for excluding transgender women in most cases from FPO competition at the highest level has a legitimate business purpose? We'll have to wait and see to find out. Maybe the biggest thing in Natalie's favor that she did not have in her California lawsuit is legal precedent. Legal precedent just means case law with similar facts that has come before that you can cite as authority, as legal authority, on which to base your own claims. I'm talking about the JayCee Cooper case. This was a case filed in January of 2021. Cooper is a trans woman athlete who sought to compete in USA powerlifting sanctioned competitions. USA Powerlifting had a policy in place that individuals who were identified as male at birth but identified as female were not allowed to compete as female. JayCee falls into that category, as does Natalie. The court, for the most part, ruled in favor of JayCee and against USA Powerlifting. Incidentally, JayCee Cooper also raised this aiding and abetting claim, similar to what Natalie has raised against Laviska in this case, but it was unsuccessful in JayCee's case, mainly because the defendant that JayCee accused of aiding and abetting these discriminatory practices was the USA Powerlifting Minnesota chapter. And they tried to argue that this chapter acted independently from USA Powerlifting, but ultimately at the end of the day, the court held that's not a separate entity, and so you have to have a separate entity present in order to successfully bring this claim of aiding and abetting. In Natalie's case, obviously, Laviska is a separate entity. That might be a stronger argument here in Natalie's Minnesota case. USA Powerlifting also tried to raise the legitimate business purpose defense, but that didn't work, in part because USA Powerlifting's policy was poorly written, and there were some statements made by USA Powerlifting's leadership that were not helpful. Thankfully, when it comes to the PDGA and the Disc Golf Pro Tour, all policies are perfectly written and nobody ever says anything stupid, so they should be all set. One final difference here that might make a difference is that we are in state court in Minnesota, not in federal court. So it's likely that the defendants will not have any favorable jurisdictional arguments to make on their behalf. Just keep in mind, Natalie was prevented from playing the final 2 rounds of the OTB Open in Stockton, California on jurisdictional grounds. The trial court in California ruled in Natalie's favor, and the Ninth Circuit Court of Appeals reversed that decision on jurisdictional grounds. It didn't reverse or overrule any of her legal arguments. In other words, if the Minnesota court rules in Natalie's favor on the same or similar grounds as the court did in California, there will likely be no jurisdictional issues that the Disc Golf Pro Tour or the PDGA could argue to get it reversed. Based on our quick scan of the filings, it looks like the earliest we could expect an answer back from the defendants would be around July 11th, 2023. If you've watched our videos in the past, you know those deadlines frequently get extended, and we'll bring you the latest news and analysis relative to this case once we've had time to receive it and analyze it and get it organized and out to you guys. Really appreciate you watching. Please like, comment, subscribe.